Thank you everyone for attending this webinar. I'm grateful to you for taking the time to join us. We wanted to provide some information on the new extradition scheme, which will soon be affecting our day-to-day practice. Many of you we know already, but to those of you who are unfamiliar, 5 St Andrews Hill is a leading extradition set with a relatively large team of specialist extradition and international law practitioners. Our webinar today is split into 3 talks. You'll first hear from Natasha Draycott, then from Rebecca Hill, and then finally myself. At the conclusion, there'll hopefully be a short period of time for questions, and Ben Keith and David Williams will also be joining the panel for this section. If you don't get a chance to ask a question, then please don't hesitate to contact us directly. We will be happy to help. I'll now hand over to Natasha Draycott.
Thank you, Louisa. Hello, everyone. I'm going to start by giving an overview of the new surrender arrangements. On Christmas Eve of last year, the UK and the EU announced and published the text of the EU-UK Trade and Cooperation Agreement, or TCA, following the UK's exit from the European Union. These arrangements were ratified into domestic law by the European Future Relationship Act 2020, which was given royal assent on the 30th of December of last year. Slide 2, please. Now, subject to what Rebecca is going to say, the framework decision is no longer in force, but the surrender arrangements under the TCA are sufficiently similar to those under the framework decision to require few changes to be made to the Extradition Act. The new arrangements do not apply to EAW cases where a person was arrested, and this includes provisional arrests, or extradited prior to the 31st of December of last year. And other European arrest warrants issued prior to this date will be treated as arrest warrants for the purpose of the new surrender arrangements. It's also of note that Iceland and Norway are no longer Part 1 territories for the purpose of the 2003 Act. Slide 3. You will see on this slide the key principles are contained in Article 78 and how they very closely reflect the language of the framework decision. I don't propose to read those out, but they're there to see. And slide 4, please. The new arrangements reflect the core elements of the European arrest warrant and the Iceland-Norway schemes. Like other schemes, the new arrangements include limited grounds upon which to refuse to execute an arrest warrant, and also expeditious timetables within which the surrender process must be completed. And on this slide, you'll see Part 3, Title 7 of the TCA creates an arrest warrant. And as with the European arrest warrant, this seeks the surrender of a requested person for the purpose of conducting a prosecution or executing a custodial sentence subject to defined exceptions. And I put some of the key principles here, and you'll see the language and contents are very similar to the framework decision. The scope is the same at Article 79. You can look these up in the TCA, but the grounds for mandatory and optional refusal are identical in Articles 80 and 81. And also the trial and absence provisions are the same at Article 81 as well, and so on. But there are a number of important differences in the text, and these are the nationality exception, the political offence exception, and the principle of proportionality, which Louisa will go on to explain in more detail. Next slide, please. One of the most significant provisions to arise from the agreement, which is now enacted in the UK, is the re-redesignation of EU member states. The remaining EU member states, the EU 27, had previously been destined for redesignation as Part 2 territories, but they will remain designated as Part 1 territories by virtue of Section 11.1 of the FRA. And this is important because the continuation of the Part 1 treatment of the EU 27 is an obviously positive outcome because it avoids the diplomatic procedure which is associated with Part 2 requests and should ensure that the process continues to run smoothly. The disadvantage, however, is that the EU remains a third country for extradition in the eyes of the EU 27, and therefore the UK may anticipate encountering struggles with competing requests and also in seeking the extradition of foreign nationals to the UK. Now, there are three important differences which are worth noting, and they are these. First of all, the Court of Justice of the European Union no longer has jurisdiction over the new surrender arrangements. They are now overseen by a specialised committee on law enforcement and judicial cooperation set up for the purpose of the agreement. The second difference is, in contrast to the framework decision, Part 3 of the TCA makes no reference to mutual trust or mutual confidence in one another's legal systems. There is a change of tone here, but the practical importance is likely to be limited, as the principle of mutual trust, as we're well aware, is a defining characteristic of the EAW scheme. But I think the most important difference is that the UK has lost access to the second Schengen information system, or SIS2. Now, this was the most used information sharing system for security across the European Union, and it provides real-time alerts for EAWs being issued. And the UK was one of the most frequent users of the SIS2 database. I think it accessed it approximately 603 million times last year. So the loss of SIS2 is a huge loss for the UK, as it now has to rely on the Interpol database to access uploaded red notices. And the problem there being that this is something which is really not routinely used by all EU 27 states. As you'll be aware, a lot of requested persons were stopped for example, routine traffic offences, and using SIS2, officers were able to tell immediately whether they were subject to an EAW. Now, this is no longer possible, and it does account for the recent drop in the number of cases at Westminster Magistrates Court. Thank you very much. I will now hand over to Rebecca.
Thank you, Tash. So I am going to deal with the practical ways we might approach European arrest warrants moving forward into the new regime. Next slide, please, Tess. Thank you. And we essentially think that there are three different categories of cases that we will need to consider moving forwards. The first is European arrest warrants issued, certified and executed before 31st of December 2020. By executed, what I mean in fact is where the requested person was arrested before 31st of December 2020. The second category is European arrest warrants issued and certified before 31st of December 2020, but where the requested person had not been arrested on the 31st of December 2020. And the third is entirely new arrest warrants issued under the TCA agreement. So Louisa will deal to a greater extent with challenges to the latter two of those categories, but I will touch on the first two. So if we can move to the next slide, please. Thank you. First of all, European arrest warrants which were issued, certified, and where the requested person was arrested before 2021. As recently as a couple of weeks ago, we all felt that there was a clear lacuna or potential for a lacuna in the law, some ambiguity between the withdrawal agreement and the TCA as to what would happen to European arrest warrants where the requested person had already been arrested and proceedings were ongoing. As many of you will be aware, this was challenged by a number of members of these chambers through a habeas corpus application to the divisional court, where they sought to argue that the European arrest warrants were no longer enforceable, no longer had legal power, and as such, the continued detention or remand on bail of the subjects was unlawful. That is the case I've set out there, Polakowski and Westminster Magistrates Court, which was heard last Friday and in fact was dealt with extremely quickly for reasons one might imagine. Judgment was handed down yesterday. You may very well be aware of the outcome, but in summary, the court held that European arrest warrants which have already been executed and will continue to be enforceable as if the transition period has not ended. so they remain with all the legal force that they had as of the 31st of December. Furthermore, they set out that the provisions of the European arrest warrant will continue to apply in its unamended form to extradition cases coming before the courts now, where the arrest took place before 31st of December 2020. You'll see that's in paragraph 23 of the judgment. And finally, when construing parts of the Act which implemented European law, domestic courts will continue to be guided by decisions of the CJEU. That's paragraph 32. What that means, in theory, is that European arrest warrants executed last year or before will proceed to be dealt with and challenged in precisely the way they were before Brexit, before the transition period ended. So nothing should change in respect to those ongoing proceedings that you have. Polakowski was, as I say, a challenge by way of habeas corpus, but the divisional court chose to deal with it as a judicial review instead. The importance of that is that their decision in refusing permission on that application is therefore final and unappealable, and thus this position now will not change. So that's where we are on European arrest warrants executed last year, with one caveat. It's notable that, notwithstanding what's said in paragraph 32 about the ongoing relevance of CJEU decisions, in a case also handed down yesterday, NSY, it's a divisional court case concerning a Romanian request, where the requested person raised challenges in respect of dual criminality and specialty relating to disaggregation of a sentence. And when the divisional court came on to review the law and legal principles in relation to specialty, rather than going first to the fact that we're signatories to the European framework decision and thus can have mutual trust and confidence in Romania, they actually looked first to the fact that Romania was a signatory to the European Convention on Extradition 1957. They would never have done that last year, and it suggests that, notwithstanding the jurisprudence in Polakowski, there may be some deviation in the way that the courts approach the relevant questions, even with old and executed European arrest warrants. Moving then to the next slide, please. Thank you. So this is the second category, European arrest warrants issued and certified last year or before, but not executed until 2021. The treatment of these arrest warrants is pretty straightforward. It's set out explicitly in the Trade and Cooperation Agreement, Article Surrender 112, which states that where arrest has not taken place, this title shall apply, this title being Title 7 of Part 3 as set out by Tash. So the new arrest warrant surrender regime will apply. So those European arrest warrants, whilst issued as European arrest warrants, we simply treat as arrest warrants, and all the challenges that arise under the new regime, which Louisa is going to set out, are open in respect of those warrants. Next slide, please, Tess. I'm just going to touch briefly on challenges which might arise from interpretation as opposed to the explicit new provisions in the Trade and Cooperation Agreement. So interpretation of the Extradition Act now will obviously be guided, given the principle of conformity of interpretation by reference to the historic CJEU decision in Pepino. When one looks to interpret our domestic jurisprudence, the courts obviously will look first at the language of our Act, but then will look to the treaties which found it, where before obviously that was the framework decision, now that's the trade and cooperation agreement. And the question is therefore whether the Extradition Act, which has in most respects not been amended, can be interpreted in different ways now. And this is all up for argument. There's no clear answer on this at all. So I would suggest that when one looks at our cases, it would probably be helpful to assess whether the CJEU jurisprudence is to our client's advantage. So if defending, and if there were a section 20 point, for example, the requested person was present at his trial, but was not present at an appeal where a material change was made to the sentence, for example, we may wish to rely upon the CJEU jurisprudence in 2PCAS or ARDIC. And in that case, we would wish the court to interpret the European the Extradition Act now in a way that's consistent with the way it has always been interpreted and consistent with the European jurisprudence. I recently had a case where it was on the 5th of January. The case was listed for extradition hearing. The requested person attended and was arrested on a replacement European arrest warrant because of a Section 2 argument that arose in respect of the original European arrest warrant. As such, we actually proceeded to extradition hearing on the European arrest warrant as an arrest warrant under the new scheme. It was a Polish case, and I wished to rely on the arguments about judicial independence in Poland. You'll all be familiar with the Wozniak case. At the time, counsel representing the judicial authority, reacting on the spur of the moment and just advancing the best argument he could at the time, suggested that it could be said that the interpretation of a judicial authority, which had applied under the framework decision, no longer applied under the new agreement, and consequently it wasn't necessary for the court to engage in any exercise of review of the independence and impartiality, the qualities of the judicial authority. In fact, that position wasn't maintained on reflection and in submissions after the event. But that just shows how there will be arguments about how one interprets the language now as distinct from how it was interpreted previously. If I was going to argue that CJEU jurisprudence remained applicable to my case and the historic interpretation was still relevant, I would have argued that domestic law has in the most part adopted and incorporated the principles espoused in the CJEU decisions, because when almost all of the key issues under the framework decision were litigated before the divisional court had regard to CJEU jurisprudence when making its decision. And as such, it can be said that that jurisprudence has been incorporated into domestic law and thus continues to apply. Secondly, I would have argued that the TCA adopts the framework decision regime and language so closely that it would be perverse if language had one meaning under the framework decision and a different meaning under the TCA, especially given that where the TCA seeks to deviate from the framework decision, it generally does so explicitly. So that's how I would approach it if it was beneficial to my client to rely upon principles derived from CJEU jurisprudence. Conversely, when appraising the case, you may take the view that actually CJEU jurisprudence is unhelpful, and you wish to argue that the language of the Extradition Act should now be afforded a different interpretation given the different underlying treaty. And if you were to argue that, you could rely upon the dicta in Polakowski at paragraph 18 that I've set out here. Any legal question involving rights or obligations said to be derived from EU law should now be approached in the first instance through the lens of domestic law. And it may be possible to go back to some more historic pre-2003 decisions if that is helpful to your client. But in essence, it's all up for grabs. It can all be argued, as you can see, in both directions. And really, I think we have to just be creative in analysing our particular client's case and to find the best arguments for their benefit. And Louisa is going to deal now with the specific challenges which arise under the new act, new agreement, which didn't exist before.
Thank you. It's really helpful to hear about a practical scenario which Rebecca was able to explore and to look at the new regime, as these experiences are few and far between at the moment. And that's really why we wanted to host this seminar. My section of the talk follows on from where Rebecca left off. I'm going to go through the challenges which can be brought under the new arrest warrants. As has already been highlighted, for any arrest for extradition, or now surrender as it's labelled, which takes place after the 1st of January of this year, the proceedings are going to be carried out under the new regime. And as already mentioned, where a requested person has been arrested on or after the 1st of January on a previously issued EAW, that EAW will be simply treated as an arrest warrant. You've heard Rebecca highlight parts of Polakowski, and in that judgment, it was stated by their lordships that as a matter of constitutional principle, the starting point is the domestic legislation. The arrangements under the TCA have been implemented by the UK European Union Future Relationship Act 2020, and it's therefore necessary to look directly to the terms of the TCA to understand where the differences lie between that and the framework decision. As you've already heard, the new surrender arrangements broadly reflect the framework decision, but there are some significant deviations. The following points of difference are notable. So here on the slide, you'll see that the objective under the Trade and Cooperation Agreement, which should say TCA, I've just noticed, under Part 3, you've got there the first article there setting out the objective under the TCA, and there's no mention of mutual trust and confidence within another member state's legal decisions or criminal justice system. So there's a different focus. You'll see from the text there that the focus is on a respect for democracy, rule of law, and protection of fundamental rights and freedoms of individuals, including as set out in the Universal Declaration of Human Rights and the ECHR, and on the importance of giving effect to the rights and freedoms in that convention domestically. So that is the new focus, and it may provide some scope for challenge where there are concerns regarding the relevant state, the relevant requesting state, upholding those principles. So, for example, a case that we're all very familiar with, Wozniak and Schlabitz, which is due to be heard in March, concerns challenges arising out of legislative changes in Poland, which significantly reduce the independence of the Polish judiciary as against the government and the ruling majority in parliament. Those criticisms could feasibly be used to mount a challenge to Poland upholding the rule of law and protecting fundamental rights regarding Article 6 of the ECHR. Similarly, criticisms which have been levelled against Viktor Orban and his government in Hungary for using authoritarian tactics to entrench his rule or its rule could arguably provide a basis for a challenge with regards to Hungary's respect for the principles of the TCA. Saying all that, there is likely to be a limit to the scope for such challenges or limit to them being successful, since there is a presumption of good faith which the UK treats our extradition partners with, and it's unlikely for that to disappear. However, it's important to focus on the differences in language used, and it's worth bearing that in mind when thinking of new challenges. Next slide, please. Natasha's touched upon one of the differences under the TCA, There is no longer, the Court of Justice of the European Union no longer has supervisory jurisdiction over disputes. So we've got a new specialised committee on law enforcement and judicial cooperation that determine disagreements. There is within the TCA a section entitled Dispute Settlement that appears under Title 13 of the TCA, and it's clearly directed at addressing trade disputes. It's not entirely clear how it will be used to resolve criminal justice matters, but that, of course, remains to be seen. Next slide, please. Another key difference is under Article 77, which relates to proportionality. It's a principle, and it is in the second article under the surrender part of this at TCA. So it's next only to the main objective that I've already highlighted. It's clearly, therefore, an important guiding principle under the TCA. And unlike the requirement under Section 21A of the Extradition Act, it's not combined to extradition cases. So there's a clear difference there. There is a focus on the arrest warrant being executed where it's necessary and proportionate to do so, taking into account the matters identified in the text that you see there on the slide. Focusing on the rights of the requested person and interests of the victims, the seriousness of the act, the likely penalty that would be imposed, the possibility of the state taking measures that are less coercive than the surrender of the requested person, particularly with a view to avoiding unnecessarily long periods of pre-trial detention. Looking or thinking of Section 21A, subsection 3 under the Extradition Act, which is the point of comparison, you'll recall that there is some similarity to what's labelled the specified matters under that section, which includes the seriousness of the conduct, likely penalty and possibility of less coercive measures. But there is a difference in language between Article 77 and Section 21A. Section 21A states that a judge must order a person's discharge, where with regards to those specified matters that are mentioned, extradition would be disproportionate. And you can see Article 77, cooperation through the scheme as a whole is governed by this overarching principle of proportionality and specific reference to avoiding unnecessarily long periods of pre-trial detention. And so it's relevant to note those differences to see whether it's a benefit to your client to mount a challenge upon those differences. And it may well be arguable that the guidance issued in Mirashevsky can be disregarded. Next slide, please. The next article to draw to your attention is Article 82, and that provides a political offence exception. The new regime establishes a political offence exception which is not found under the framework decision. It states that an arrest warrant may not be refused on the basis that it is a political offence, and that's defined there, unless the UK or EU member states notify the specialised committee mentioned that the political offence rule is to be applied only in relation to specifically categorised terrorism offences. And those offences are defined under Article 82, paragraph 2. Where such notification has been made by a requesting state, the executing state may apply reciprocity, and that's under paragraph 3. This is different to the law concerning extraneous considerations under Section 13 of the Extradition Act, and that's where extradition can be barred if the EAW has been used for the purpose of punishment for political opinions. This new exception relates to political offences, not opinions, so it's a quite different thing. Next slide, please. The next important distinction is in relation to dual criminality. The framework list of offences has been removed, and that means that there's a requirement for dual criminality to be proven in each case. Section 12 of the 2020 Act has repealed the relevant provisions under Section 64 and 65 of the Extradition Act relating to the framework list category. There is, however, a parallel list of offences contained in Article 79, paragraph 5, but it must be opted into by each of the states, and a declaration in those terms made pursuant to paragraph 4. If that does happen, it's expected that the Extradition Act will be amended again to include exceptions to the dual criminality requirement by reference to that list. Article 17.9.3 also makes it clear that dual criminality should not be a bar to extradition in cases involving group liability for offences of terrorism, drug trafficking, or serious offences of violence. That is different from the framework decision where no such provision existed. However, given those categories of offences were included under the old framework list, there's unlikely to be a practical difference. Next slide, please. The next important distinction is the nationality exception, and that appears under Article 83. This is a departure from the position under the framework decision. It introduces another opt-in bar, so it's an opt-in nationality bar. It's worth noting that under the transitional provisions, only Germany, Austria and Slovenia elected to engage their right not to extradite their own nationals. And it remains to be seen whether it will be a similarly limited number of states who choose to use that protection. Next slide, please. That's the remaining part of Article 83 dealing with the nationality exception or nationality bar. Next slide, please. Thank you. So the next important distinction with the framework decision is under Article 84, and that relates to diplomatic assurances and other guarantees. It doesn't appear, as I've mentioned, in the framework decision, and that means, but in practice, it means that the assurances that we're familiar with in the context of extradition will continue to be used, but it's now enshrined within an article under the agreement. You'll see there that assurances can be offered in respect of whole life cases, whole life sentence cases, transfer of sentence, and that's after trial in the requesting state. So where the requested person is a national of the executing state, they can get an assurance that that person will be returned after trial and serve their sentence here. Or on grounds that there are substantial grounds for believing that there's a risk to the protection of the fundamental rights of the requested person, which is the sorts of assurances we often see, the diplomatic assurances relating to, for example, prison conditions, etc. So next slide, please. That brings us to the conclusions. It's hopeful that this webinar has provided you with an overview of the new landscape. It remains to be seen how the courts will deal with these new challenges, but we hope that this webinar has given you some ideas on how to approach existing EAWs and new matters under the TCA. We're grateful to you for attending, and we look forward to exchanging ideas about the new processes in the months to come. As mentioned at the beginning, there's a Q&A button if you wish to ask any questions. And at this point, I will introduce or bring in Ben Keith and David Williams, who are going to join this part of the webinar to answer any questions. Thank you.
Louisa, I've seen a couple of questions which have come through. The first is just a practical question about what is happening at Westminster. I think I can probably answer that. Since the 1st of January, so far as I understand, and probably the people attending this seminar would be able to tell us better than me, only a handful of new arrest warrants have appeared for initial hearings. I think less than 5. There have also been a reduction in the number of European arrest warrants which have been brought before the court. So the impact thus far has been a significant reduction in the volume of cases. That said, obviously lockdown is going on at the minute, which does make criminals easier to find if they're at their home address, but also means they're less likely to be apprehended on the street up to no good, and consequently discovered to have outstanding proceedings against them. Although, of course, the Schengen system can't be checked in those circumstances. So we will very quickly start to see a reduction. There's a second question, which is how exactly is the use of Interpol notices going to be used in practice to found arrests. Perhaps Ben, you could answer that one.
Thanks, Rebecca. We're still trying to work out exactly how the Interpol notice works. We think there's been one or two arrests under an Interpol diffusion notice, which is a sort of red notice light. So rather than a full extradition request via Interpol using a red notice, it's a diffusion notice via the National Crime Agency. We know there's been one or two arrests on those, but they will effectively be the notification that an individual is wanted. It's not as good as Schengen 2. It's not as fast. It's not as easy or able to communicate properly. So there's a question as to how that and then the bill that went through last year in relation to using red notices to arrest people on will change the process of European arrest warrants, and whether in fact we will use that to found provisional arrests. I think we will. Because up until there's a bill that went through last year, and we can sort of justice on this. Prior to last year, you couldn't be arrested only on a red notice in the UK. You had to go to a judge in order to have an arrest warrant certified, or go via the Foreign and Commonwealth Office, the Home Office, to get a full notice request. So it's a slightly cumbersome procedure, and so it's not quite clear how European states are going to use that in order to apprehend people, whether they'll just send an arrest warrant, whether they'll just send a diffusion notice, or whether they'll send both at the same time. And then we will have to see, and they also don't contain an awful lot of information, so we'll have to see how they marry up or don't marry up with the Form A's, and how our courts decide whether or not they are suitable for arrests or not. I think from a client perspective, the problem with them is that they don't contain very much information. I think they contain less information than a Form A. And so you're arrested on a warrant and it can say individual is wanted for serious fraud in Poland, for instance. And that's going to make it quite hard to make an effective bail application or for a judge to grant bail when they don't really know very much about the case. So that's going to make things interesting. I don't quite know. There's a couple of other questions I think have come up in the box. I don't know whether anybody wants to jump in. Dave, there's the question, do you have any, I'm going to sort of play tennis. Do you have any views on the interpretation of the grace period until the end of February, unless anybody else wants to answer that?
I don't have any particularly strong feelings about that. I think, well, from what we've seen in both the way that the court dealt with the habeas action and NSY, the decision yesterday, and I think NSY is particularly interesting, but I think that there is the possibility that effectively the provisions of the TCA are going to be interpreted in a way which, as lawyers in England and Wales, we're more familiar with than the way in which provisions have been interpreted sort of over the last 10 years or so. So in fact, there's been an increasing drive towards interpretation in line with EU law principles as we sort of came to grips with the framework decision, its direct effect, then Pepino and so on. But I think we're going back to a much more simple interpretation. And if you're prosecuting these cases, then I think that's quite a nice opportunity, because personally, I think some of the complexity and technicality that was present in the European arrest warrant scheme flowed from areas of EU law and interpretation and the CJU decisions. And I think it's likely that the court will take any opportunity to interpret these further provisions in quite a simple way. So I think grace period will be, you know, if it were ever challenged, you get one of those decisions that say grace period is an ordinary English word, and we'll give it that definition for the purposes of interpretation now that our guiding principles are the law in England and Wales. But in that respect, I think it goes back to what Becky was saying about the view that was taken by the Crown acting for the judicial authority, albeit in very difficult circumstances on the day of that hearing. I think there is a big opportunity for both judicial authority and requested persons lawyers to argue for new or different or more limited interpretations of the provisions. Effectively, I think all of that's open for argument again. And I think the really interesting question, and one which is totally unresolved at the moment, is whether the law is going to allow different interpretations of Part 1 of the Extradition Act, depending on which underlying instrument that part of the act is being dealt with in any one case. And I think that's a really interesting question. I don't think they can allow that to happen, but I think there are some real tensions between the differences in the underlying instruments, which will come to the fore eventually. So those are kind of the cases that I'm personally excited about on interpretation.
I very much agree with you, Dave. There's another question here. What is the procedure for initial hearings at Westminster under the new arrangements? Are the usual considerations such as identity, etc., still done in the usual way? Yes, initial hearings are exactly the same, save that there is now also an obligation arising from the TCA that a requested person be notified of their right to free legal advice in the UK and in the requesting state. So that is a material difference, which won't make a great deal of difference to the way that we approach European arrest warrants, but which will have to be pointed out. And no doubt if that's forgotten, if that information is forgotten, we could attempt some sort of challenge in respect of that, though I doubt that would get very far. Another question. Paragraph 3 of Article 80 provides that where a requested person has been surrendered but was convicted in absentia and applies for a retrial in the issuing state, detention will be reviewed in accordance with the domestic law issuing state. This appears fairly bland and doesn't seem overly onerous on the issuing state. Do you think this will give much scope for pre-surrender argument on lengthy detention periods? Anyone have any views on that?
I think the answer, is that sadly, it's not going to make very much difference, and I think we'll maybe as few people will be able to mount arguments. But the problem is that pre-trial detention, excessive pre-trial detention, is in fact endemic in a lot of systems. For instance, Poland still has real problems. It's had a pilot judgment against it, which only been discharged recently, and over Article 5 and a lack of pre-trial detention. And what tends to happen in Poland is that people are detained in pre-trial detention for a significant period of time, and then on the day of the trial starting, they plead guilty and released on time served. And that is a system that operates in a number of countries, particularly Hungary, Poland, parts of Romania and Czech Republic as well. And so I think we'll have to see. There is a real problem with pre-trial detention, but we've not succeeded in, defence have not succeeded in places like India, where pre-trial detention can be 5 or 6 years. So it seems unlikely that we're going to unfortunately get very far with the other issues. There's also a second question I was going to quickly tag that on the end of it, which is in relation to section 21B and less coercive measures. In fact, Louisa wants to ask this. Louisa is going to deal with the 21B question, so I'll hand over to her for that.
Thank you. I if you want to say something, please do. But I mean, my interpretation of the objective and the way that it's set out at the initial part of the TCA under the surrender sections is that there's very much a focus on less coercive measures. So I would hope that there would be some more engagement in those procedures, in those sorts of requests, to try and make sure that there isn't these lengthy pre-trial detention periods that requested persons are subjected to. And there's certainly an argument to say that there should be a greater emphasis placed upon those sorts of arrangements. But then I suppose against that, we've got the fact that under the TCA, there's differences in the cooperation that we now have, or the tools for cooperation. So I would hope that there's an increase, but I don't know in practice whether that will in fact happen. I don't know whether there's anything else anyone wants to say, but we've sort of come to the point where we would say this was about a 45-minute webinar. So I propose to wrap up unless anyone's got an itching desire to say something. No, in which case, thank you very, very much for attending today. And as I said before, it'll be interesting to have further discussions as matters go on to find out different issues that people are raising in these matters and see how the courts respond. Thank you very much for attending today. It's made it worthwhile seeing a large number of participants here. I think we've broken over the 100 mark. So thank you very, very much for attending. We really appreciate it.